So, call to order and welcome everyone to the Monday, May 5th, 2025 Town of Sykesville, Maryland Planning Commission meeting. Small agenda tonight, but interesting one. First order of business is the approval of minutes of our April 7th meeting. I'm assuming everyone's had the chance to read those. Any comments, corrections or issues with those minutes, should I say? Nope. In which case, then I move that we approve the minutes of the April 7, 2025 meeting, seconded by Brandon. All in favour? Aye. Unanimous. Moving on to our business agenda, which is to consider, discuss, act upon an updated concept plan for the Warfield development. And Joe, I'm going to ask you if you will give us a staff report and then invite everyone to explain.
Thank you, Mr. Chairman. So, as you said, before you tonight is the updated concept plan for the Warfield development. Property owners have submitted this for your consideration. The subject property is a total of 90.57 acres. It's located in the Planned Employment Center zone. There is an approved 2016 concept plan and preliminary development plan for the property, which lists the various breakdowns of percentages of land uses. Before you this evening is obviously a modification of some of those. Specifically, the Office Research Institutional Hotel Light Industrial section was reduced by roughly 4.5 acres. The retail service, though similar in nature as far as acreage, most of the, or actually I think all of the acreage shown on the revised concept plan is located within the public rights-of-way. The residential section was increased by roughly 17 acres to 30.59 acres of residential. And the open space was increased, though most of it is still Cary University Park. 26.81 acres plus or minus 5 additional acres spread throughout the property. There's also a list of bulk standards shown on the concept plan. These bulk standards meet what's currently approved for the Warfield development in the existing preliminary plan and pattern book, with the exception that the setbacks for front-loaded townhomes has been added. So this is not currently listed on any approved plan or in the pattern book that has been previously approved. I do want to note that the PDC references, or the PDC Planned Employment Center District, references traditional neighborhood design principles, which refers to parking and loading areas that are typically hidden as much as possible. So just pointing that out to everyone. As far as the analysis, the submitted concept plan proposes the utilization of approximately 9.82 acres of existing public rights-of-way for retail and service-oriented land uses. This approach does not constitute a practical or permissible interpretation of required land use percentages outlined in the Planned Employment Center District. Right-of-way areas are not developable land under the town zoning ordinance, rather they are reserved for public infrastructure, including roadways, sidewalks, and utilities. Additionally, the applicant does not hold ownership of some of these sites. Specific portions of the right-of-way for inclusion, further rendering this use for meeting the zoning requirements impermissible. While the town ordinance does allow for the inclusion of right-of-way in the calculation of the overall parcel size for the purposes of the residential and non-residential density, this does not include or the extent of treating the right-of-way as developable land for the purposes of satisfying these land use allocations. There's a similar issue with the 2.39 acres of right-of-way proposed for the Office Research Institutional Hotel and Light Industrial uses on the southeastern portion of the site. Though the acreage is smaller, the same zoning and ownership concerns apply. So there was also no reason for why that change was made from the 2016 concept plan as opposed to this concept plan. It's also worth pointing out that parcel D1/G is now labeled as Office Research Institutional Hotel and Light Industrial, whereas in previous iterations of the concept plan it was designated for infrastructure. So while staff acknowledges that this parcel is part of the overall development track, its inclusion in the land use calculation may be appropriate. It should also be clearly stated that due to site constraints, there's no likely of any significant vertical development anticipated on this particular parcel. There is a realignment of the proposed extension of Springfield Avenue. The proposed concept reflects a modification to the existing concept plan shows it swinging to the north of the existing water tower. This concept actually shows it going to the south. Staff has reviewed this revision. There's no objection or issue with the proposed realignment. And then lastly, the concept plan references the Housing Expansion and Affordability Act of 2024, also known as House Bill 538. The application does not clearly articulate how the provisions of this act apply to the Warfield site or how the applicant intends to implement them within the framework of the PEC district. So staff just recommends that the Planning Commission request clarification from the applicant regarding the relevance and intended implementation of House Bill 538 in this project to ensure consistency with the spirit of the planned employment center zoning requirements. It's also worth noting that that bill is unprecedented. So there's not a lot of guidance out there to actually show how it should be implemented. So again, we're all kind of treading on new ground with that particular bill. So based on the submitted concept plan and the issues outlined in the preceding analysis, staff recommends that the Planning Commission postpone consideration of the concept plan as currently presented. Staff finds that the inclusion of approximately 12.21 acres in the public right-of-way to meet the minimum required land use percentages for retail service and employment uses is inconsistent with the intent and provisions of the planned employment center district. Their inclusion would set an unacceptable precedent for result in planning inconsistencies, legal challenges, and misrepresentation of actual land use feasibility. The Planning Commission, or the staff recommends that the Planning Commission request that the applicant revise the concept plan to exclude all right-of-way areas from land use percentage calculations and provide an updated land use allocation based solely on the net developable acreage of the site. Staff also advises the Planning Commission to request written explanation as to how the applicant plans on implementing the House Bill 538 and how it relates to the Warfield site in the PEC district. Staff has also provided a suggested motion for the Planning Commission to consider, and obviously there's representatives here from the Warfield Development, which I'm sure are going to do their presentation, but staff is available for questions if the Planning Commission should have them.
Thank you, Joe. So, gentlemen, please.
Thank you.
Thank you.
Good evening.
Evening.
I'm Dave Bowersox, 24 North Court Street, Westminster, Maryland. I'm here on behalf of the applicant. As you see, this concept plan for amendment to 2016. It was PEC, preliminary plan for Warfield. So we are at concept at this point. We're not going to sort out the rest of the entire plan tonight. We hope to provide additional information for you so that you can have some additional insight, and perhaps we can return in June and move forward constructively with this. There were two issues raised in the staff report, as you've just heard. Succinctly, the first one is the inclusion of public road right-of-ways as part of land use distribution acreage. The second was the relevance of the 2024 HEA Act, House Bill 538. Now, the owners are here, and we also have, in terms of the first issue identified, Sean Davis from MRA, whom many of you may know already, is here with us. He can explain the technical aspects of the concept plan before you. With respect to the HEA Act, we have with us tonight Mr. Tom Cole, who has a great deal of familiarity with the act as proposed, as it was being developed, as it was adopted. Frankly, I can't think of a better person to ask questions about what it means than Mr. Cole. We have here a proposal to amend the Warfield preliminary plan to try to keep up with some changes that are happening, changes that have not only happened with the adoption of the HEA Act, changes in the marketplace, but also changes ongoing now here in Sykesville. You may recall that in March, this commission, as that night constituted, unanimously recommended the Thrive assisted living facility be favorably considered by the town's Board of Zoning Appeals. You may or may not be somewhat gratified that they did just that, which you recommended they do. And that was approved by the Board of Zoning Appeals, allowing that to move forward last Tuesday night, I believe the 29th of April. So this plan also reflects some changes relevant to that parcel. So without further ado, I'm going to let Mr. Davis tell you about the plan, including the road right-of-ways and other features of this plan.
Okay, thank you.
Thank you, Dave. Mr. Chairman, members of the commission, for the record, my name is Sean Davis. I'm a principal with Morris Ritchie Associates. I can't see Kevin, so I'm going to just pull this back a little bit. See everybody? Great, thank you. Thank you for giving us the opportunity to speak with you tonight. Again, as Mr. Bowersox mentioned, the goal here in revising this concept plan is for two reasons. First and foremost is to amend the concept plan to show an assisted living facility or the assisted living use on parcel B in accordance with the Board of Zoning Appeals decision last Tuesday night. That's necessary for them to move forward in their planning and engineering. And then the second aspect of this is to take into account and take advantage of the opportunities that are presented by the housing, by the HIA Act. As Mr. Cole will testify shortly, in the end, the HIA Act allows us to develop up to 6 units per gross acre. With 6 units at 90.57 acres, that yields approximately 543 total homes. And in order to account for those 543 homes, 145 of which are currently constructed in the Parkside at Warfield, parcels E and F as illustrated on this plan, in order to accommodate the remaining homes that are afforded under the HIA Act, we've revised this plan accordingly. There are proposed homes in parcels A, parcels C and H, and parcel D. In order to do that, we had to, in keeping with the principles of the Plan Employment Center, we've amended the concept plan to illustrate the land uses that are required under the PEC. Although I respect the staff's report and recommendation, I would disagree with it. Unfortunately, when we look at the Planned Employment Center zoning ordinance, when it talks about the distribution of land, let me just flip to that real quickly. All it says is the following percentage of land uses shall be provided in the PEC Planned Employment Center development proposal. Office 20 to 55%, retail 10 to 20, residential 10 to 35, and open space no less than 25. It doesn't say only in developable land. It doesn't say only in the net land. It just says those are the percentages. We've utilized the 90.57 gross acreage continuously since 2016 for density purposes. And all of the gross land area was included in the concept plan that was previously approved. Although we recognize that utilizing the road right-of-ways may not be, if you will, in keeping with some of the conversations that we've had, technically it's our opinion that it meets the law, the PEC zoning code. And in order to take advantage of the HIA and maintain the integrity of the PEC, we have illustrated how we can do that on this concept plan. We don't expect any decision tonight. We're here to get your thoughts, your input, so we can go back in, make modifications as necessary, and ideally be back before you in June with a revised plan to accommodate what we're able to agree to. And that's our presentation.
Thank you.
If you look through the general notes on the side of the concept plan, there is, it's actually briefer than it was back in 2016 because, for example, in 2016 there was a number of different property owners and leaseholders, and now that's obviously been consolidated. But otherwise, it's fundamentally the same as it was then. This is the concept. If and when this is ultimately approved, we will come back in, we will amend the PEC preliminary plan, which shows all the details and whatnot, and the pattern book that accompanies that. And then once that's amended, as specific proposals come forth, we would go in for final plan approval for those, just like we did with parcels E and F, now the Parkside at Warfield. I welcome your questions.
Thank you. I have questions. I'd kind of like to hear from the expert on the bill.
Perfect.
As to how that bill in any way dictates that this plan would be A, legal, and B, has anything to do with the bill. I'd like to hear that.
That's great.
If you would. Yeah.
Then we'll both be up for questions and answers.
Yeah.
Good evening, everyone. My name's Tom Cole. As it relates to the Housing Expansion and Affordability Act, I've been engaged by the City of Laurel, City of Annapolis, Howard County, the Maryland Affordable Housing Coalition, and Preservation Maryland to brief them on this bill. My background on this bill is that I worked with the governor's team to come up with its elements and then worked on the bill as it passed through the legislative process. And I believe you're going to get a highlighted copy of the bill. Now, before I get into the text of the bill, and don't worry, this isn't going to be a lengthy presentation, the comment about it being unprecedented, I do have to disagree with that preliminarily, respectfully, in that it's the beginning precedent, because all of the powers that a city or county has are by way of the Express Powers Act. The state has the original powers and authorities, and they've delegated that to cities and counties to administer those powers. And the land use power, the land use article under state government is the way by which these powers are delegated to cities and counties. What the Housing Expansion and Affordability Act did was it said we have an affordable housing crisis. It was specifically directed at affordable housing. And it said, we want to respect the powers that have been delegated to the localities while also providing some guardrails to say housing can still proceed under certain circumstances. And they created a category called a qualified project. You'll see qualified project defined throughout this bill and referenced throughout this bill. And a qualified project has two components, one of which relates to the affordability of the project, and the other one relates to where it is located. And as it relates to the Warfield property, you'll see in your handout that was distributed to you on page 10, it is on property that was formerly owned by the state, consists of more than one building, includes at least one building that was built more than 50 years before the date of the application for the project, and is appropriate for redevelopment as determined by the Secretary of Housing and Community Development. Those criteria were selected with Warfield in mind in particular. This was a project that was discussed by the legislature during the course of this bill's deliberation. And so to the extent that this would ever be interpreted by the courts, the legislative intent could not be more clear that the Housing Expansion and Affordability Act applies to this project. Now that does two things. One, it applies the additional density that Mr. Davis referred to. But secondarily, there is an additional provision here related to unreasonable restriction or limitation. And that is on page 9. You'll see a unreasonable limitation or requirement is defined there. Now it says amounts to a de facto denial by having a substantial adverse impact on the viability of an affordable housing development in a qualified project, or the degree of affordability or affordable dwelling units in a qualified project, or the allowable density or number of units of the qualified project. And then one more reference before we pull it all together. If you then turn to page 15, the bottom of page 15, section 7505, it states a local jurisdiction may not impose an unreasonable limitation or requirement on a qualified project under the subtitle, including limitations on or requirements concerning height, setback, bulk, parking, loading, dimensional, or area, or similar requirements. So I'm going to leave it to the zoning attorney and the planner to say what provisions are being utilized there. But more globally, the HEA, without a doubt, applies to this project. Secondarily, the affordable units that are being provided make it a qualified project. Being a formerly state-owned property and meeting all of those criteria makes it a qualified project, which means it gets two things, and only two things in terms of what I'm talking about. One is the density increase, and two, a prohibition on unreasonable limitation or requirements on the project. And so when you are evaluating that, some of the things that you could look at in terms of being unreasonable restrictions or limitations or requirements are the bulk regulations, are any impositions on this project that would threaten the viability of the project, threaten the number of affordable units that might be provided on that project. It encourages planning boards and the like to look at those requirements in context of what it does to the project, where you don't really have the ability to do that uniformly on the other projects that come before you. So with that, I would welcome, I could talk about the HEA all day. I promise I won't do it with you now, but happy to answer any questions.
Okay, so I think we understood before you gave your presentation
Okay.
that the Act applies to this property and this project. What I'm a little unclear about is in your professional opinion, would it be an unreasonable impediment for us to say that if you include, for example, all of the retail on this property on the public right-of-way on land that you do not own and that you cannot build on, and we say that simply doesn't meet rational requirements, how would that be an unreasonable restriction?
So this, I want to be clear, this relates to your land use authority. So if you are making a determination as to who owns what, and that would not necessarily be covered by the HEA. What I would encourage you to do is when you are looking generally at the commercial requirements for this zone, and if those commercial requirements, they would be bulk requirements. If those commercial requirements, independent of where they're designated on this plan, if they would threaten the viability of the project or limit the number of affordable units that could be allowed under this project, then those commercial requirements would be an unreasonable restriction and limitation. Your determination that a certain road is not appropriately included for certain uses and the like, and because of who owns it, that's a separate determination. But I would recommend that determination seems to me to sit within a larger frame, which is the commercial requirement impositions on the project.
Okay, thanks.
Well,
Makes sense. Any other questions or comments or issues with this particular? No? Okay, well, thank you for that presentation.
Thank you.
Thank you very much. So, that being said, how do you propose, if assuming that retail remains part of this project, and right now we have the language of the PEC to go by that it really should remain part of this project, the percentage of it we can negotiate, think about how it could possibly be done. But how could you possibly build retail on the public right-of-way on land that you do not own?
The reality is we can't.
You can't.
There is a portion of parcel D2 that has identified the dining hall, that has been identified as a potential retail or office institutional hotel. From now on, let's just call it office. So we don't have to go through all of the entire list of uses under that category. So you have office and retail as part of the dining hall. If there's one thing that the last 9 years since the original concept plan was approved and 7 years since the property was transferred has taught us is that there is no retail market. And we recognize that, and we have gone through and we can illustrate numerous ways on which we've tried to market, which we have marketed and tried to sell, and the parcels A and B as retail to no avail. So we recognize that there's not a market for it. We recognize that there's an opportunity with the HEA trying to maintain the principles of the PEC in form by saying, okay, here's 10% of the land area that is designated for retail. This is what we have proposed. Although we do not own the vast majority of the right-of-ways, we obviously still own a portion of the Springfield Avenue connection from the roundabout back to Buttercup Road. Although we don't own those were always included in the density calculations, in the prior land use concept or the concept plan, they were just shown as open space. We had, a specific proposal that we were pursuing, and as is always the case with any project of this size, things change. I mean, as you guys know, I've been involved with this probably now for almost 30 years, from the original charrette held out in the building where there was a plan. We developed a plan. Well, it changed from there to something different when the Warfield Development Corporation Board was established, to what it was when when I was sitting on the Warfield Development Corporation Board. We have a proposal from the Roger and his team, Mr. Conley and his team, and it was very specific. Well, as of last Tuesday, even that plan changed with the identification of parcel B as assisted living, turning it in from red to purple. So the plan is evolving. And what we're trying to do is we're trying to say, okay, technically we meet the letter of the law in the PEC, but we recognize full and well, just as you do, that we're not going to be building any retail within the public right of way.
Right. The problem I have with that is what you then have is a plan which is an ironic plan. In other words, it says it's doing something, but it means something else. And if we know that we cannot build in that, how is a rational, responsible public body could we vote for something that we know that cannot possibly happen?
It's a recognition of what can literally happen. It's the recognition of the realities of the project, the marketplace, and what's being offered with the HIA. If it was just the zoning, if the HIA didn't exist, and we came in and we were proposing this, you'd say, well, you only have 36 homes left, or however many homes you have left from a density standpoint. Why would we change all this? But that's not the case anymore. We have the HIA, which does allow more density,
Right.
a lot more density on the property. And that is the justification for the modification.
It seems
A reality that the market that we once thought, and hoped, we never thought, but we had hoped that it would come to fruition, is not coming to fruition.
there's no doubt that HB. Sorry, does somebody else want to chip in?
Yeah.
Daniel, go ahead.
Yeah, you had mentioned validating the market and a number of things that you've done to determine that retail is not viable. Like what are some of those things? Like how do you validate a market?
So, I'm sorry, I don't know your name.
Danny.
Yeah. So back in 2016, when we had submitted the concept plan, and part of the PEC zoning ordinance requires the applicant to submit a market study. We submitted a market study done by Valbridge in 2016, which illustrated the market potential for residential. It also illustrated that there was limited, if no market, for the employment and for the retail. We submitted that specifically to illustrate that there was big questions and concerns regarding the viability of the retail and the office. Okay. Since then, we got the PEC approved, and we were on our way, working on the plans for parcels E and F. The owner of the property, the developer, hired numerous retail and office brokers. I developed probably 30 plans for the various non-residential parcels showing a variety of retail and employment uses that were put out to the market. And there was no bites. I mean, there were bites for things that we knew probably would not go well. And we said, no, we realized that's just not going to happen. So
I'm not a developer, so what does put out to the market entail?
No, I think I'm good. So we develop marketing pieces. The brokers go out and they have a list of retail tenants that they customarily work with. They show this site to them. I even believe there's an International Council of Shopping Centers show in Las Vegas every May. I believe it was even illustrated and brought up at that show. So the brokers, their goal is to go out and show this to the retail world and say, hey, listen, this is a great opportunity. It's right off Route 32. Here's the number of trips you have, so on and so forth. Are you interested? nothing happened.
Earlier, you said something along the lines of we had hoped to be able to do this, but that you never intended, and then you stopped. What were you trying to say before?
No, we hoped that we would be able to one day be able to fulfill the goals and aspirations that were discussed in a meeting in 2015 or 2014 with the retail employment. We knew it was, we believed it was going to be very, very difficult back then, which is one of the reasons why we specifically, along with Dennis Hoover, I was responsible for writing the PEC zoning ordinance. We included in the PEC zoning ordinance the specific requirement to provide a market study because we wanted to make sure that everybody understood the market realities. That's what we did. So,
Do you think the market has changed since we mentioned prior to COVID? COVID from whatever 2020 to 2023, 2024. Then we're like in post-COVID. I don't know. Like, does it warrant a restudy to kind of there's return to offices. Like large companies. Like I feel like it's a different phase than back in 2016.
I definitely think that's something we can definitely look into. I believe, based on my experience with a number of other projects, we're going to find the same thing. The reality is that the Carroll County market, which was illustrated then, hasn't changed in terms of the core market is along 27, right? Is that the main road?
26.
No, not 32. 26. Sorry, it's been a while since I've been there. It's along 26. And that pulls the entire market. And that literally, back in 2016, it was assumed that maybe we could draw, if everything else worked, 5,000 square feet out of that market, which would have negatively impacted that market for Warfield, which would have taken over 30 years to build the proposed office that was proposed at the time. So, I mean, we recognized that we were pushing rope uphill back in 2016. We did everything we possibly could to market it. And, the same thing happened when I was on the Warfield Development Corporation board. We would have people who would come in and say, hey, listen, I want to, I'd like a 500 square foot office. And we're like, okay, we don't have 5,000, we don't have 500 square foot offices. We have, these existing buildings that we would like to renovate, but we can't do it on a 500 square foot lease. So.
Yeah, I mean, I totally get that if that's reality, and if independent third parties are like verifying that, and I think it's important that, and I would definitely love like a revalidation of that, because there's one thing coming from where the incentives are on you to like develop as much residential as possible and minimize office, and then there's independent third parties that are saying like this is revalidating that this is the state of the world and the market.
So the one thing, and I appreciate what you said, and we'll definitely take a look at it, but the one thing that's really, really important for everybody to understand. It does not make any economic sense for a developer to sit on this land for 7 years, which is basically what's happened. They have done everything they possibly can to move this land. Okay, they're paying debt. They're paying, there's money going out the door, and there's no more money coming in to do this. So they have every incentive in the world to market this and to sell this. So
Sean, can I just take us back to the plan itself?
Oh,
We've got
honor. It's a red honor.
Yeah, the red's on.
Okay.
So we've got House Bill 538. We've got the Sykesville Planned Employment Center District zoning language.
Yep.
We've got our 10-year plan, our comprehensive plan, and the language which talks about flexibility and negotiation. So somewhere between those three, we have to reconcile these two documents, the Planned Employment Center and the House Bill. We have to do that.
Mm-hmm.
I don't know quite how we're going to do it. In my opinion, including the public right-of-way in your land calculations is not the starting point for that,
Okay.
in my opinion. Okay? The fact is we're going to have to do what we have to do here, but I don't think personally, I'm not speaking for my colleagues here, I don't think this is the right starting point.
What would you suggest?
I would suggest that we rediscuss and renegotiate the actual land use designations for each percentages, for each of those parcels and what's possible and what isn't possible. That would be a starting point from my point of view. But I don't
Would
think
you-
that's. I think that's something that's an impediment. The actual assumption of ownership, if you like, of public right of way. That's more of an impediment than it is a good starting point.
Would you, in that discussion, would you be amenable to discussing the percentages that are required in the PEC zoning code?
I think we would have to do that. And in fact, our comprehensive plan demands of us that we do that. The language is very clearly in there.
Okay.
I don't know how else we could possibly move forward if we didn't do that, because these two things require slightly different approaches.
They
You know,
do.
we can't, we can't just stick to this if this is now the law of the state. We can't. So
Mr.
that's.
Chair, we respect exactly what you're saying,
Mm-hmm.
and I'm delighted to hear your sentiments about that. We recognize when we produced this and submitted it, that was going to start a conversation, which fortunately it has.
Right.
And I think our goal is to provide a little bit more information, as the one commission member, Danny, has suggested. Is there anything else any of the other commission members would like to see in preparation for us coming back in June?
Random.
So you have, on the notes over here, you have 543 homes, correct? Is that taking into account the 145 that are already there? Okay, so that's 400 homes on this extra land here. Now, you already know the schools in this area are overburdened already.
Okay.
How does the HEA, how does that protect our schools? And I mean, we can't justify bringing in another, let's say, 400 students into schools that are already overcrowded.
So I would suggest that, I don't have the answer to that question right now, but we can go through a school analysis between now and June, based on the types of units that are being proposed for the remaining 398.
Yeah, I was rounding. That's why I said 400.
I'm sorry, I was being a smart ass. To take into account those additional units that are being brought in, the types of units that are being brought in have different pupil generation requirements. So, for example, a multifamily unit does not generate the same number of kids as a single-family detached home does. So we can go through an analysis and present that to you in June.
What would the bill say about that? Would school capacity be an unreasonable
That's kind of where I was
impediment?
going.
Yeah.
That's kind of where I was going with this. Was
And while you're adding that,
Sorry.
how about like public safety and things like that? Because
Sure.
that
And
400 more homes is gonna generate more calls of some nature.
So the good news right from the start is this law does not address or change your adequate public facilities ordinance in any way. As a matter of fact, it was written originally to impact adequate public facilities, and that was taken out. So the methods by which your locality currently meters out housing units based on adequate public facilities would continue in implementation going forward. As it relates to public safety, the HEA is silent on public safety either way. And I would say that is the same for your zoning ordinance. Your zoning ordinance doesn't factor in public safety in any direct way anyway. So whatever APFO you have in place will continue to apply.
We have to go through, as we did back when we were working on the PEC preliminary plan. Remember, there's 3 stages. There's the concept, then there's the preliminary, and then there's the final for individual parcels. We had to go through at the PEC preliminary plan and pass your adequate facilities analysis. So we would have to do the exact same thing at that point in time as well. So that would address specifically the schools, EMS, fire, police, sewer, water, all of it has to be addressed. So obviously, we're not interested in proposing anything that would negatively impact any of those public facilities.
Sean, if I may, Mr. Chair, yeah?
Yes, please do.
Podium or?
No, yeah, come to the podium, please, then we can hear you.
Steve McLeaf with Warfield. I've heard a few things. I think we have, there have been a lot of studies done, and we have some new faces here and some faces we've seen for years. And we should probably, in a good way, we should probably get the most current studies back out to you all, and then they're quite voluminous, but have a discussion maybe about those in June. One of those studies is, to answer your question further, APFO is top of line. Every time we submit a plan, as Mr. Davis said, the final site plan, it has to go through that test. But we also part of our contract when we acquired the property was to get a fiscal impact study to address exactly what you're suggesting. And we, over time, on our own, had that updated. And so we should probably revisit that too, because the way that fiscal impact study looks at things, including schools, fire and EMS, police, so on and so forth, is it looks at things on a net basis. It looks at the additional revenue generated, but it also looks at the additional cost. And the consultant, the economist that we used was actually an economist who was suggested to us by the town. We've actually liked working with them. Your economic development department in Carroll County has used them over the years. So we can bring that up too, because I think that will help address some of your questions on that.
The last thing I would say on that is it's important to recognize in any development of this size and nature is that it doesn't all happen at once. So obviously everything would be phased in terms of how this would physically be phased. For example, if things went swimmingly and we were to move forward in June or July, well, you're probably never going to see anything happen in the ground for at least 2 years, maybe even 3. And then from that point, for build out, say it's 5 years, I mean, we're 8 years from that stage, which gives the opportunity for us to plan for those public facility improvements.
Okay.
So we have market study, we have fiscal impact.
It would be helpful to get them a little bit more in advance of the discussion, since they are voluminous. It would be appreciated.
We can get them out, I can get them out later this week.
Thank you.
And then we talked about fiscal impact.
What are the actual procedures to modify the PEC?
To modify the zone itself, there would be a recommendation from the planning commission up to council,
Mm-hmm.
but that's a council action to
Okay.
modify.
Mm-hmm.
I would also mention this, just given the amount of information that might be coming and the voluminous nature of all of the market sites.
Great
Maybe
word.
it's better that if that information is submitted, maybe a brief summary of those, but we can submit those to the planning commission, and maybe instead of June, maybe a July meeting, just to give more time for the planning commission to actually digest some of that.
And Joe, once everybody gets into them, if we can even bring the consultants back out to help. It may not be necessary, but we can keep that on the
It's up to the commission, yeah.
Sure. Okay.
Yeah, that's great.
If it's possible, although I respect what you're saying, I think it's in all probability, if we could stay on the June and possibly the July agendas, just so that there's a spot for us, we'll get those studies to you as quickly as possible.
You can't be here in June. They're not, I would, since council cannot be here in June, I think we'd like to push it back to July.
Okay.
Okay. I realise that there's a dynamic here, but I think it's important that we have representation here. Okay. Does anybody have any other comments or questions or issues that we can deal with right now? No. Then I'm gonna move a motion based on what we have in front of us tonight. I move that the Planning Commission continue this matter to its July meeting due to the inappropriate inclusion of approximately 12.221 acres of public right-of-way in the calculation of required land use percentages. At this point, the use of right-of-way for this purpose is inconsistent with the provisions of the Planned Employment Centre District and doesn't constitute developable land under the town zoning ordinance. This continuance will provide the applicant with an opportunity to revise the concept plan to exclude all right-of-way areas from the land use percentage calculations and resubmit updated figures based solely on net developable acreage, or provide a written explanation of the relevance and proposed application of the 2024 Housing Expansion and Affordability Act, HB 538, to the Warfield site, and demonstrate how its implementation aligns with the purpose and requirements of the PE zoning district and other applicable requirements of the town code. Do I have a seconder for that motion?
A second.
Second. All in favour? Aye.
Aye.
So, gentlemen,
See you in July.
See you in July, and we'll be happy to discuss this, and we have to do what we have to
Kevin,
do.
you know the July meeting?
The 7th is the first Monday in July. I don't know whether or not there's any special provisions for the July 4th July 4th holiday.
Wait, the day before then, we meet a Friday.
Thank you all very much.
Thank you for coming. Thank you. We'll see you in July. Thank you very much.
Yeah, you can, it would be 7 o'clock, regular scheduled meeting.
Yep. Good.
The town is. Thanks. Thanks, everybody.
Thank you.
Thank you.
So, moving on from there to town updates. Kevin?
Yeah, I don't have a whole lot, so I don't know what the last update I gave you guys on was for Sykesville Station, but since then they have gotten approval from the HDC for their exterior alterations. HDC did suggest a few changes, but gave them the thumbs up to move forward. MHT also has to approve that as well, so we're going through that. But they submitted a site plan to us and to the county to start our staff review, so that'll be coming before the planning commission. Potentially in June, potentially in July, but soon. So the Sykesville Station project is moving. We've gotten submittals, and it's starting to get some approvals. I'm sure you've noticed, and Joe can speak to this a little bit, the streetscape project is ongoing down at the south end, so hopefully that stays on track to get that done, before farmers market season really kicks off. Other than that, I'm sure you guys are aware of elections tomorrow, so if you feel so inclined to vote, then
We shall. Is there any timeline at all for the parcel A development or parcel B development up there, the assisted living facility?
any timeline for when it needs to be developed?
Yeah.
I mean, well, we need to go through this whole process first, get this concept and then a preliminary plan approved,
Right.
the updates approved before they'd really be allowed to move forward at all.
We haven't heard from them about the timeline for submission of those things at this point.
They have asked for a pre-submittal meeting with the county
Mm.
on that site, but again, from a town perspective, it's a little premature for us to start moving forward with any sort of actual reviews of the site.
Okay.
Oh, that's interesting.
So the sequencing depends on these conversations for their
Correct. So nothing can actually happen on parcel B until they have an updated concept and updated preliminary plan
Okay.
approved.
Okay.
And then at that point, parcel B can begin development.
Okay.
So we got some work to do.
Looks like we're going to get a lot of reading to do. That's for sure. Yeah. I think this looking at the planned employment centre district and looking at House Bill 538 and taking advice about what that means.
They're pretty far apart.
They really are, yeah. So they have to be
Help.
reconciled. I don't think so. Yeah, I think so.
Yeah,
All right.
I'm sure.
Sorry, with respect to the streetscape, is there an updated timeline for that? And how, is that going to overlap with the farmer's market, or is there anything known about the
Yeah,
timeline?
so I'll just say this, we're getting real close to wanting to have those conversations about what we can do in the farmer's market, in case that's still
Okay.
pending.
Mhm.
So what's under construction right now is what we hope to have done before farmer's market.
Oh, cool.
So there's still gonna be some work that happens on Oklahoma,
Mhm.
and maybe like right in front of the French Twist, I should say maybe in front of the French Twist. There's gonna be some work there as well. But if that's under construction and the parking lot is open, the farmer's market can still utilize it.
Cool.
Again, I haven't said this publicly yet, I think, so this might be the first time, but we're like real close.
Okay.
So I'm feeling it's gonna be the first few weeks of farmer's market, we're gonna have to come up with some sort of different plan, but, we're gonna talk to the contractors over the next few days and figure out, how much pushing can they actually get done.
Okay.
It'll be close.
And just another clarification for me, if we do change the PEC percentages, that goes before council?
That would go before council. Any amendment to the PEC district, specifically the PEC district, would have to be a council action.
And so tonight, we didn't give any parameters around where the negotiation
Right.
occurs. And so,
Well, I think it starts here, doesn't it?
well, yeah, I mean,
It starts here.
it does, but we didn't say stay within this range
No.
or anything.
Not
like
at all.
that.
No.
Right.
So I can say this, if part of the discussions, with the proposal shows what percentages you might want to change things to within the PEC district, then that would be the recommendation that goes to council. Doesn't have to be, a blank slate that goes to council. It can be a specific recommendation from the planning.
How much?
Interesting.
I mean, from what they say here, in reference to this bill, some of those percentages are going to be imposed upon us, whatever we want for this site. If it's the law that says we have to include X number of units on this site, the fact that we might want to keep 38, 39, 40% retail or whatever it might be, doesn't matter.
I think it says up to
Well, I think-
those units.
And I think that's
yeah.
where the interpretation of what that code actually says.
Okay, so Karen, we're going
Just despite what was said.
to need some guidance on that.
Yeah.
I think that's actually really important for this body
Mhm.
to understand what is our interpretation. And I didn't ask the question earlier, but I'll ask the question now. What is the town's view of this? It seemed like sort of a bully pulpit earlier in reference to the way that they're explaining legislative intent.
Sure.
And it's a pretty profound argument that the gentleman that helped write the legislation is the one that's actually speaking. I mean, that is profound.
Well, and again, I'll say this.
And mentioning
as
that
staff-
Warfield was considered during the discussions of the
Yeah, I mean,
bill.
we have a few properties in the state where Warfield was one. We all
Yeah.
do that.
Yeah, and I'll say this, and we can share this obviously with the applicant as well, and certainly will if they don't rewatch the video. I'll say this: there's anytime a new bill is passed, if it's not clear exactly how it needs to be implemented, usually there is, and I hate to say it, but usually there is some sort of litigation that would happen to help clarify how those things are implemented.
Mhm.
So if we have a different interpretation of what the specifics are and how these things need to be implemented, then we have the ability to at least try to express that. And I think, part of that conversation can be, here's what we think it says. You might disagree, but is there a middle ground that can be found?
Okay. So I guess we will wait at this point for their submissions and their arguments, and they're going to run by Karen. And Karen, I'm looking forward to.
I'm sorry I won't be here in June.
That's fine, actually. I would prefer it to be in July because I'd like some time. It's going to take some time to look at this, and there's no way I want to have this meeting without an attorney present. Okay, so we need to do that. Anything else on any of our issues tonight? Nope. In which case,
questions from the public ever? Just in general?
Absolutely. If you want to ask a question, by all
I was
means.
hoping there'd be a public
But
comment.
if you wouldn't mind coming up to the.
I was hoping I would get to say this in front of the Warfield developers.
Well, you absolutely could, but you need to.
My
chip
name's
in.
Dan Anderson, live in Sykesville here, and I just wanted to praise you all for having the patience to entertain that. And the other side, I would like to say as a taxpayer, why are we entertaining these changes in the plans? I mean, I actually, 2016, I've been thinking about 2018, and it's like 9 years now, and we're still talking about changing the plan. And as I understand it, they haven't done anything except the townhouses that we can see, and the town has sued them. So I don't understand why we're entertaining anything from the Warfield developers, quite frankly. I'm kind of quite aghast about it, and I'll leave it at that. But I mean, it's just like it's fine to have due process, and I have to bow my head to you for even entertaining it. But me personally, it's very frustrating. As a matter of fact, I think this planning commission should be saying you owe us the properties now, and then they countersued us, and they're still here, giving you guys changed plans for something that happened. I'll tell you now that all the people I've been talking to lately are not going to have any of that, so that's not going to go well. I think they need to ship off. Thank you.
At present, they are the owners of the property, and they have a right to submit
I see.
development plans, and we really have a responsibility to give them due process. And if we didn't do that, then we would have a lawsuit on our hands, I think.
Well, one last point I would just say, as they were talking, with the legal jargon and things, admittedly I don't understand. That's all your expertise area. What I do understand
Not
is
really.
there's an agreement in place that they've had now since the 2016, and then the transfer in 2018. The part of their agreement they held up was building residential. So if you're going to entertain anything, I think it has to say residential comes last, because I have zero faith that that's not going to come first, and then everybody else be damned. So
Well,
please consider that.
We will, but again, bearing in mind what this piece of legislation
Sure.
demands that the town does, we can't ignore it.
I'm with Joe, though. Yeah, having the writer, the author, or the arbiter of that law here on behalf of them, I think we definitely need a critical view of it from the other side as well.
Absolutely.
Thank you. The laws are made, and then we arbitrate them, right?
Very good.
Thank you.
Thank you.
One other part just to mention is that this body is not a political body, right? So that's another piece to this. I would point out on page 11, just because they said that we can get up to 543 homes. That number could be lower. And so if you read the highlighted portion that we all have, and an area zoned for mixed use, a qualified project may consist of residential development with density limits that do not exceed the greater of the following, and then 6 units per acre is one of those things. And then there's another provision about our residential zones. And so they were right in terms of their scripting and notes that they can go up to, but it could be lower, especially based on what you had said, Chairman.
Okay, any more? Anything else? Further comments? Very good, in which case I move that we adjourn.
Second.
Seconded by Brandon, all in favour?
Aye.
Thanks for coming, and we'll look forward to future meetings.